How is it? How well to know about my work as a. I'm gonna go to just on the line. I need to go to Somerset because they have a Zara there. I think that's the only one, right? Nobody's gonna see me. I'll be fine. Important. Okay, thanks. I'm unmuted or I'm. Good afternoon, everyone. Today I am joined by Clinton County Sheriff Sean Dush, Kelly Schaefer, Executive Director of The Voice for Clinton County's Children, and members of my office from the Criminal Trials and Appeals Division, Chief Robin Liddell, Assistant Attorneys General Melissa Palapu, Danielle Bennett, and Caitlin Kirby, Criminal Investigations Division Chief Aubrey Sargent, and Victim Advocate Joanna Delp, to announce criminal child abuse charges that we filed today against Joel and Tammy Brown and Jerry and Tamal Flore, all of Dewitt, Michigan. Now, the state believes that the Browns and Flores conspired together to adopt dozens of children who were removed from previously abusive biological homes and subjected them to prolonged, routine, and systemic mental and physical abuse under the guise of discipline, and all for personal financial gain. They have been charged with the following: Joel Brown, a former child advocate with the Children's Services Agency within the Michigan Department of Health and Human Services, is facing a total of 5 criminal charges. 1 count of child abuse in the first degree, 1 count of conspiracy to commit child abuse in the second degree, 1 count of child abuse in the third degree, 1 count of interfering with a crime report, and 1 count of failure to report child abuse. Tammy Brown, his wife, is facing 3 criminal charges: 1 count of child abuse in the first degree, 1 count of criminal conspiracy to commit child abuse second degree, and 1 count of child abuse in the third degree. Tamal Flore faces 18 criminal charges: 6 counts of child abuse in the first degree, 1 count of child abuse first degree committed in the presence of another child, 1 count of conspiracy to commit child abuse in the second degree, 3 counts of child abuse in the second degree, and 6 counts of child abuse in the third degree, as well as 1 count of interfering with a crime report. Her husband, Jerry Flore, is charged with 12 criminal counts: 6 counts of child abuse in the first degree, 1 count of child abuse in the first degree committed in the presence of another child, 1 count of conspiracy to commit child abuse in the second degree, 3 counts of child abuse in the second degree, and 1 count of interfering with a crime report. Between the Brown and Flore families, nearly 30 children have been placed under their care either through fostering or adoption. And these charges stem from the documented mental and physical abuse of 8 of those adopted children. These charges for the abuse of 8 victims represent the offenses we have found that have not exceeded the statute of limitations, but not necessarily the totality of abuse victims in these homes to the best of our understanding. This case was initially referred to the Clinton County Sheriff's Department by Child Protective Services after they received a complaint regarding suspected child abuse. Charges were later initiated by the Clinton County Prosecutor's Office, and following a preliminary exam, those previous charges against Tammy Brown and Joel Brown were dismissed, and the charges against Tamal, Flore, and Jerry Flore were reduced. The Department of Attorney General worked with the Clinton County Prosecutor's Office to take over the investigation earlier this year, and as a result, any outstanding charges against the defendants were subsequently dropped so that the Department of Attorney General could renew the investigation. With that said, I think it's important to note that we have erected a conflict wall between our prosecutors on the criminal matter and our attorneys who have a duty to represent the Department of Health and Human Services. Now, we cannot deny that the initial investigation needed more work, and the initial CPS investigation could have had better documentation and more accurate notes. Those CPS summaries of early interviews were copied into the police reports, making those reports not completely factually accurate as well. However, those inaccuracies are largely argumentative. So, for example, the vast majority of the inaccuracies are just word choice changes that do not affect the actual disclosures of abuse or the substance of the case. One such example was whether an item that was used to strike a child repeatedly was a decorative boat oar or a wooden paddle. Whatever one calls that item, it doesn't change the fact that a wooden item was used to inflict physical abuse. So that's one example. But to ensure the accuracy of our charges and theory of the case, upon taking over the investigation, the department took numerous steps to confirm the information in the initial reports and sought additional sources of information as well. So for instance, we performed the following tasks. We interviewed 10 of the adopted children, adults and minors, and multiple child protective services and DHHS employees, reviewed photos and videos from the home, reviewed employment information, reviewed adoption subsidy, payment, and medical benefit records, and received new medical evaluations on all the potential victims. My department's Criminal Justice Bureau is composed of career prosecutors who have decades of experience handling child abuse prosecutions. We focus on a victim-centered approach to investigations centered on the best practices in the field. And what our investigation ultimately discovered is the same as what the initial investigation uncovered. These children were subjected to routine and systemic mental and physical abuse in the homes of Jerry and Tamal, Flore, and and Joel and Tammy Brown. That there was interference with the investigation by Joel Brown and the adoption of well over 30 children altogether by the Brown and Flore families was for monetary gain. And while previous reporting on the CPS reports, in this case, did correctly point out some inaccuracies, previous coverage of this case really serves just to highlight the importance of having trauma-informed, trained forensic interviewers, investigators, and also prosecutors. The allegations in this matter are heinous and egregious. In the area of child abuse, the harms caused to an individual's mental health are often, unfortunately, overlooked. Abusive behavior by any parents, adoptive or biological, is unacceptable. It will not and it cannot be tolerated. Our investigation has also highlighted just how much the law in these areas really needs to be amended to combat these types of crimes, which is likely much more prevalent in our state than any would care to admit. First of all, the statute of limitations is far too short. Prosecutors only have 6 years from the time of the latest offense to bring charges. The significant problem with this is that the victims are children and thus unlikely to report significant abuse until they are free from their abusers. We believe there should be an amendment to MCL 767.24 to place child abuse in the same categories as sexual assaults. There's simply no reason why, at the very least, child abuse matters can't be treated the same as criminal sexual conduct third degree and brought pursuant to the current law, which provides a 15-year window or by the time the victim is 28 years of age. We believe that Joel Brown used his decades of experience as a CPS employee to skillfully and successfully hide the abuse happening within his home and to help the Flores hide the abuse in their home as well. It is clear that many of the child witnesses in this matter were coached and that the investigation was compromised. However, there is no real criminal statute that exists to prevent this from happening. The child protection law does not directly address this issue, and the witness tampering or obstruction of justice charges are simply inadequate. Either the criminal code or the child protection law should be revised to eliminate the ability of an abuser to manipulate a child in this way and not suffer consequences for the tampering. Furthermore, the child protection law should be revised to provide for mandatory cooperation with CPS and to require that evidence of witness tampering or manipulation results in a felony. One reason why this abuse was able to go undetected in the Flore home, the home of the most significant and apparent abuse, was due to the fact that all the children were homeschooled. School is often a safe place for children where such abuse is discovered either by the school, by the teachers, or the staff, or by the child being away from abusers long enough to be able to disclose what's happening inside their home. While there's nothing wrong with choosing to homeschool a child, there has to be some sort of monitoring so that those children also benefit from those protections. Finally, one of the biggest loopholes discovered through our investigation resides in the adoption subsidy program's rules and regulations. Currently, there is no true accountability or oversight in this program. There is nothing statutorily requiring a person who receives funds from this program to prove that they are actually using the money for the child. And currently, the parents can do, quote, anything that incorporates the child into the home with that money. That could mean buying a bigger house, going on vacation, purchasing cars, doing absolutely anything, because the argument could easily be that it allowed for the child to be incorporated into the home. There's also no requirement that the child receive any services or that anyone account for how these funds are utilized. There are no check-ins on the family to see how the child has been incorporated into the family or how they are adjusting. There are also no caps in how many children a person can adopt or how much funding they can receive. The Flore and Brown defendants were easily able to manipulate the system to receive over $1 million tax-free. There should be upgrades to this program that would, 1, put caps on how much funding a household can receive, and 2, requirements on obtaining services and care for the child, and 3, mandating accounting on a yearly basis for how these funds have been spent. Arrest warrants have been prosecuted or have been processed for all 4 defendants, and they will have until Friday, December 8th to turn themselves in. In addition to everyone else up here, I'd really like to thank our special agents, Sam Miller, Bob Lalone, and Jennifer Kapuscinski for their very hard work on this case. And with that, happy to take questions.
Very well.
Do you know how long the abuse has been here?
I'm going to turn some of these questions over to Assistant AG Melissa Palico, who's our lead attorney on the case.
The abuse for the children who are part of the charge group really happened from the time that they came into the home. We have adoption records from 2007 noting the adoption for other children, but as far as the charges here, would be for those children.
You mentioned that there's a conscious bond that was being hospitalized and for representing abuse. Why would that be necessary? Are you looking at charges against the?
Well, I will say that nothing is off the table, but we do it for multiple reasons, but really because, you have individuals, obviously, from our department that, their job is to defend DHHS employees. And with a case of this nature, and not certain to where it might lead, it's always just best to be cautious and to ensure that there is that conflict law in place so that the prosecutors can do their job and no concerns with the work of our civil attorneys, also defending the say CPS workers or anybody at DHHS in the event that anything arises is just best practices.
Are you looking into some of the inaccuracies that were in those reports? I mean, I think in some cases, some of these CPS workers, some of the quotes are in the report. These kids never said that they didn't asked about the in the report. Are you looking into that at all, or is it mainly focused on these?
Well, what we're here about today is focused on, the couples. I will say this, we want to make sure, of course, at all times that DHHS and their various agencies are exercising best practices. And so I think that there's no question that anything that we've learned from this particular investigation, of course, that information will be shared with CPS, with DHHS, to make sure that they are exercising caution, that they have the best possible practices so that the reports are accurate, accurately state whatever any witnesses have indicated, including child witnesses. But there's a difference, of course, between incidental or accidental issues where perhaps things are copy and pasted in a manner that creates an inaccurate record. There's that, and then there's something more intentional that could rise to the level of crime. But I will say this, I think that our staff has learned a tremendous amount during the course of this investigation. And of course, we think it's very, very important that all of that be shared with DHHS so that they're using very best practices so that all of their reports properly reflect the evidence in this particular case and in all cases.
You mentioned that you believe that this is an amendment to state law, child abuse law, to include that with criminal sexual conduct. Are you alleging that was there any criminal sexual conduct in this case, or are you just seeking to give more truth to that?
No, well, the way that the criminal sexual conduct statutes have read in terms of statute of limitations, for instance, and I think this is still true for CSC 3, not 1, which has no statute of limitations anymore. But a child was given until the time they were 18 years old, plus an additional 10 years, in order to make that report. Understanding that, again, you're a child, whether they have had, been the victim of sexual assault or a physical assault, they need time to process that. And clearly, it's going to be very difficult for a child to make that report while they are still minors. But the child abuse statute is just different than the CSC statute. And so they're not afforded the same period of time. Time was virtually everything, I mean, not murder, but virtually everything had a 6-year statute of limitations. And then over the course of time, that was changed as it pertained to a lot of different types of criminal offenses, including criminal sexual conduct. But unfortunately, with child abuse, just doesn't reflect that. And of course, a child abuse victim who is a victim of a physical assault or, where mental anguish is what, the allegation is. I mean, they should have all the same opportunities to report as a child who is a victim of a sexual assault. But my understanding is we're not claiming here, and we are not alleging that there was any child sexual abuse, child physical and mental abuse.
Sorry, just a follow-up. You mentioned that Bill Brown is a former child advocate. How long has he not been?
So Mr. Brown was placed on unpaid leave in 2022 and has since been terminated from MDHHS. It's unclear whether he'd be able to regain employment with the agency if he were to be removed from the Central Registry for Child Abuse. And he was, just for background information, a department specialist in the Office of Family Advocate, where one of his roles was reviewing CPS investigations to ensure they complied with the rules. He worked there well, at least for DHHS, since 2002 in various divisions, including being a CPS investigator previously.
The kids' ages range really from, the youngest was, 7 to 15.
Why is your office prosecuting this case and not the local prosecutor?
So it started off with the Clinton County Prosecutor's Office handling this matter. I will say this, Clinton County has a very, very small staff. So there's the elected prosecutor, and my understanding is, are there 3 additional APAs? There's 5 now? Okay, so you have the elected prosecutor and then 5 APAs. And my understanding is they only recently, yeah, so they weren't even fully staffed. If you compare that to the Department of Attorney General, right? Between our criminal prosecutors, both our trial prosecutors, as well as our appellate prosecutors, what do you have, about 80? 61 with the appellate prosecutors? Okay, so, all right, so we have about 61 prosecutors in our department. That's quite a difference. The other thing I will say is this, we have a number of prosecutors and investigators on staff that have been trained in regard to child forensic procedures. And you know, those are specialized trainings. I will say personally, I'm a former child abuse prosecutor. I spent many years at the Wayne County Prosecutor's Office doing nothing. I mean, you were a vertical prosecutor and you handle nothing but cases that involve child physical and sexual abuse and also child witnesses. And that's the experience of many of our staffers. So, you know, what we find, and we try to communicate this as much as possible to various county prosecutors around the state. Sometimes, especially if you have a case of this nature, where you have multiple defendants and where you have, you know, over a couple dozen children involved, sometimes we just, you know, for staffing purposes and also experience, we're better situated to handle the case. And I think ultimately that's what happened here. The Clinton County prosecutor, you know, I think tried his hardest to handle this case, but you know, perhaps it was better suited that it be handled by us. But that being the case, of course, we reinvestigated the entirety of this case, of course, with the help with the Clinton County Sheriff's Department. You know, I think that moving forward, we're very hopeful that, you know, that the case will proceed quickly, and we feel very confident in the charges that we brought. But we do have some pretty unique experience here at the department.
Who brought the case to you?
Yeah, the sheriff.
Sheriff, you want to say why you brought these up?
I'm going to go to Talon Jack in the back. I'll call on you in just a little bit, Matt. Matt, I'll get back to you. I'm going to go to Talon Jack.
So I know that, you know, our department has talked to many of the relevant committee chairs already to reach out. Our legislative affairs director reached out to start some of those conversations. I actually just today talked to Representative Graham Filler, who represents Clinton County, and I know has been interested in this case. I think that we're going to have a lot of interest in that it's going to be very bipartisan. This is not, child abuse should not be a partisan issue. Protecting children who've been subjected to child abuse certainly should not be a partisan issue, and I don't think it will be. So I have every confidence that moving forward, we're, you know, going to be able to utilize this case, as awful and terrible and tragic as it is, but hopefully the good that will come of it is that we'll be able to make some of these significant changes in the law to better protect children and also, quite frankly, you know, tax dollars.
Sheriff, I just wanted to ask why you brought the case to the lead officer and not to bring it back to the prosecutor.
At the time this case was started, I was a lieutenant judge of the case. Leslie Melvin from CPS came to me I started working the case myself. This is not common. I haven't done this prior to this, but I know how it works. Basically, we reached out and asked for help for the case. So, and that was done by me to get that role.
Why did you think the help was here and not?
Because like the Attorney General mentioned, they have a lot more resources than what we do. And we were, our prosecutor's office is struggling with staffing issues and things of that nature. And if there's just so much more state records and things that could be obtained that we couldn't get at the local level. So that would be.
Okay, two more.
Attorney General, you mentioned earlier that this, one of the cases of thinking the Browns stopped and Texas and what do you have today that they didn't have?
Well, we're going to be introducing all of that evidence in court. And again, having, reinvestigated the case from the, top down, we feel really confident in these charges. And, I'm certain that there's going to be evidence that is introduced at that preliminary examination that was not previously introduced. And so, obviously, those are probable cause hearings. We have every expectation that we'll be able to get these cases, all of these charges, and all of the counts bound over, and then we'll be ready to take this to trial. But all of that evidence will be introduced during the course of those exams.
Last question, I'm gonna go. Name and affiliate, sir?
This is Dr. WLMS.
Thank you.
So the kids that were most recently with this family, are they still with them or where have they actually been back?
Right. So in terms of where everyone is now, the department believes that the minor children in the Brown household are being cared for in the family by an adult child of the Browns. And it's our understanding that the Flores are still guardians for one adult who has cognitive disabilities. We are urging DHHS to review this arrangement to ensure that the remaining children are in safe placements. As to the children who are alleged to be victims in the case, the minor children who are the subject of the charges are no longer in the Brown and Flores homes. Again, we have a conflict law in place, but we are really urging DHHS to take a look at all this and to follow best practices in terms of what's appropriate in terms of the placement of these children.
Thank you. We do have hard copy copies in the back of the room.